Hi, everyone. I'm Professor Josh McDaniel. I direct the Religious Freedom Clinic here at Harvard Law School. Marty was saying that he's a fish out of water. I might describe myself as a fish that swims in many waters because at the clinic we're constantly representing clients of all kinds of different faiths, primarily monotheistic traditions, but really all over the board. And when Noah invited me to come and speak here, I was reminded of one of my first cases, actually in private practice before I came to Harvard. So it wasn't a psychedelics case, but it was a cannabis case, which I understand doesn't quite qualify as a psychedelic, but in terms of setting precedents, maybe it's the gateway drug that sets those precedents. But I represented a Rastafarian prisoner in California who was seeking to use marijuana for sacramental purposes. And even in California, that was a non-starter, and he was not allowed to do so. It was a very interesting case, though. We took the case to the Ninth Circuit. The two kind of complicating factors in that case were the fact that, number one, California had legalized marijuana for recreational purposes throughout the state. And number two, within the prison context, the state had a number of exceptions, both allowing cannabis for medical purposes for prisoners throughout the state, and then also looking to another drug, peyote. The California had regulations in place that would allow Native American prisoners to consume peyote for sacramental purposes as part of their sacraments. And so part of the argument, and I think part of the strategy in terms of how you think about this from the perspective of a litigator is it's going to be difficult to argue for an exemption on its own terms. It's often much more viable and likely to be able to get an exemption if you can show that there's some kind of comparable other conduct that the government is allowing, and that we could take similar safety measures here, and the risks would be roughly comparable between the two. But even with all that, so we got a decision from the Ninth Circuit that didn't really answer a lot, which, if you know the Ninth Circuit, is maybe not too much of a surprise. But afterwards, I actually ran into one of the judges on the panel and mentioned to him that I had worked on this case, and he said, I hated this case. And the reason he hated this case was he said, I was talking to another judge on the panel, and the other judge said, I'm not going to be the first federal judge to say that prisoners can consume cannabis in prison. But on the other hand, I think the reason he hated it was because on the law, the arguments were pretty compelling, and this judge was pretty sympathetic in general to religious freedom arguments. So in some senses, this kind of put the judge to the test. So zooming out a bit, so Marty did a really good job of canvassing religious freedom law. If I could zoom out even just a little bit more, if you're looking at the trajectory of free exercise law in the United States, we obviously have the passage of the First Amendment in the Bill of Rights with the Free Exercise Clause. We have the incorporation of what we call as lawyers the incorporation of that right, or the recognition that that right applies to state and local governments under the 14th Amendment. But really, the Free Exercise Clause was relatively untouched for most of our nation's history in terms of courts and in terms of what the Supreme Court has done. It really wasn't until kind of an initial experiment by the Mormons in the late 1800s that did not go well for the religious claim, and then really kind of lay dormant for another many decades, started to pick up a little bit during World War II, and then you get to the 1960s, and the Supreme Court, for the first time, adopts this relatively robust standard for protecting the free exercise of religion. in that case, in the case of a Seventh-day Adventist, then followed that up with an Amish case and reinforced that standard. But from there, you get kind of a steady decline until 1990, the Employment Division versus Smith case that Marty mentioned, which interestingly also is a peyote case. And so it's also a case that raises some of these very similar questions. But that lost in the Supreme Court, which is, and that was the catalyst that prompted the adoption of RFRA. So it was a case involving peyote that triggered the adoption of the federal RFRA that now applies to all federal government action. And in turn, as Marty mentioned, you see this proliferation in the states. So how do we think about this kind of stepping back? So we have this federal free exercise clause that was somewhat neutered in the Employment Division versus Smith case, although the courts are kind of breathing new life into it as time goes by and strengthening it. You have the Religious Freedom Restoration Act, which is a very strong test that kind of harks back to the 1960s, that original strong strict scrutiny test that the courts adopted. But the limitation of that is that it only applies to the federal government's actions. It doesn't apply to state and local government. So it's just the federal government. And that's where the state RFRAs that Marty mentioned briefly come into play. So, and you have state RFRA. So in the wake of RFRA, you had a number of states adopt parallel religious freedom acts for their states that governed state and local action within their jurisdiction. And so those apply. The other thing that you see is a number of states have their own constitutions, of course, and their own equivalents of the federal free exercise clause in their state constitutions. And some courts have interpreted those provisions in robust ways that might also provide benefits to litigants that are trying to secure an accommodation or an exemption under state law. I guess I'll just highlight two examples of this. So these are, so there's the Ocentro case, the UDV case that Marty mentioned, but I want to look just very briefly at two state court or state law cases that have come down in the last few years. One was out of New Hampshire, the New Hampshire Supreme Court, in a case called State versus Mack in 2020. This is a psilocybin case, and the court, there was basically, Mack was charged with criminal possession of a small quantity of psilocybin, and he raised a religious freedom defense to that, and the New Hampshire Supreme Court took that as the opportunity to interpret its state constitution, and in particular, there's a provision of the state's constitution that says that all men have the freedom to worship God according to the dictates of their own conscience, provided that it doesn't disturb the public peace. And the court looked at that. It looked at the disturb the public peace language, and it said, we're going to interpret this essentially to track the old school 1960s kind of robust religious freedom strict scrutiny test that you also see in RFRA. So for all practical purposes in terms of the analysis, you're going to see a similar analysis with similar legal elements that the court is going to be looking through as it addresses it. The court did not resolve how that case should be resolved under that test. It just said, we are adopting this test and we're going to send it back, the hard question, back to the lower courts so that the lower courts can decide this. Case number two, as Marty mentioned, is this recent decision out of Utah, and this was a federal court decision. So not relying on the Utah state constitution, but relying on a very recently passed what we call mini RFRA in Utah, the Utah RFRA. And the court in that case granted a temporary restraining order and now has granted a preliminary injunction in favor of this group, Singularism, protecting both the founder and the group. And I just wanted to share just a little bit of a little bit more color on the case. So the case was founded by a man named Bridger Jensen. He was raised in the Church of Jesus Christ of Latter-day Saints, or the Mormon Church. Over the course of his life, he had experiences with psychedelics, with psilocybin, and went on a spiritual journey over the course of his life. Professionally, he became a licensed clinical therapist and had this clinical practice, and eventually wanted to start incorporating mushrooms into the clinical practice that he had. So he relinquished, but he also had this a spiritual manifestation that he was called to perform a religious function and to lead people on voyages and spiritual journeys. And so he relinquished his license and founded this group called Singularism. Some of the complicating factors, like Marty mentioned, is that Singularism doesn't claim, so this is somewhat different from other religious traditions, Singularism does not claim special access to divine truths, and it does not compel any particular interpretation or particular beliefs or belief system, or even any system of morals or ethics on the adherents of Singularism. You can come in as a Muslim or as a Mormon or as a Jew, and you can keep those beliefs and those practices in place. And the purpose of Singularism is to help you on your spiritual journey. So that by itself is a potentially distinguishing factor that you see in this case, that at least the District of Utah, and in the future maybe the 10th Circuit, had to think through. A second, obviously, is the financial aspect of this case, and the fact that it was something that kind of grew initially as a kind of a commercial type of endeavor and morphed over time into a spiritual and religious purpose. But the district court for the District of Utah grappled with these issues. It looked at it. It looked at all the evidence, and it sided with the group. On the financial point, I think a fair point is you do see a lot of case law out there, especially in the cannabis context, where courts have raised concerns over the financial aspects and whether this is basically a front for drug dealing, and it's not truly, the purpose is not truly religion. One factor that the court pointed to in the Singularism case was, although he was charging $4,000 or whatever it was a pop for these tea ceremonies, when you kind of did all the math, Bridger Jensen had given up a six-figure job that he had, making roughly $120,000 per year, and was now making roughly $40,000 per year when you totaled it all up. So the court looked at that and said, I don't think that this undermines his argument that he has a religious conviction in this case. And the fact that the group didn't claim any special access to divine truths or mandate any particular beliefs on those of those who were adhering to this, the court essentially reasoned that is a factor for courts to consider when they're deciding, is this something that's religious, but that's not going to be conclusive. So we have this decision. It's a very interesting decision worth following. It'll be interesting to see how the 10th Circuit deals with this in the event that it gets there. But also time will tell as we see where cases like this go in the future. So thank you, everybody.